Okay, so welcome everyone online and everyone in the room, and we're thrilled that you're all able to be here. So we really just have one basic rule with the schmooze, which is you only get 20 minutes. That's it. And we will cut you off ruthlessly, brutally, if you go over. The fact that we're starting a few minutes late doesn't take away from Lisa's time. We will still give you your full 20 minutes. But those of you who are presenting online, you should be keeping an eye on the chat. We will be notifying you in the chat. If you're not paying attention to the chat and you get to your time limit, one of us will step in and say, time's up. So just, be aware of that. And we're very much looking forward to the day. So I'm Cynthia Alcon. This is Peter Riley, and Peter will be doing introductions to the speakers. And let's go.
Great, let's go. So good morning. I'll just quickly introduce Lisa Blomgren Amsler. She is Distinguished Professor at the O'Neill School of Public and Environmental Affairs, Indiana University, Bloomington. She's a fellow of both the National Academy of Public Administration and Labor and Employment Relations Association, and she received the ABA Section of Dispute Resolution Award for Outstanding Scholarly Work in 2014. Welcome.
Thank you. Thank you. I am so grateful for this event. It's been a wonderful event. I'm grateful to Peter and Nancy for organizing it. Peter knows my personal connection with his family is his father, Tony Riley, was a volunteer at our Community Justice and Mediation Center, and that will be part of what I'm talking about today. And he was just an outstanding facilitator that kept us from killing each other in previous public engagement steering committees. Nancy has been incredibly generous, was a reviewer of the dispute system design book that Jan Martinez and Stephanie Smith and I did, and visited our Institute for Advanced Study at IU, and has always, just wonderful colleagues for whom I am infinitely grateful. And then Carrie, it's such a joy to have this event dedicated to the incredible breadth of your scholarship. And I'm also sort of happy that I may be one of the few people talking about just the deliberative democracy work, because it's so important for lawyers to understand their role in democracy and to become more active, leading, in my view, particularly at the community level. And you were publishing about deliberative democracy and you saw the connection. You were among the first, right? Back in 2004 and 2006. Also, you are an incredibly generous colleague. Carrie reviewed the dispute system design book drafts multiple times, and long-time relationship with Jan and Stephanie, my co-authors, because I am not teaching at a law school, and because unlike a lot of you in the room, I didn't go to an Ivy League law school. I didn't connect early in my career. Let me show you something, and that'll illustrate what I'm surrounded by. Last night, one of my colleagues, can you see this?
Yep. Yes.
This is the kind of thing I get. One of my colleagues sent me a job announcement from USA Jobs about, this is a real job, someone who's going to be a conflict manager for between communities and grizzly bears. I just thought you'd find it entertaining. There is detailed skill set below, but it's not what we usually think about when we talk about conflict management with lawyers. So I'm going to go ahead and start this thing. And I've called it Collaborative Governance and Lawyers' Duty to Strengthen Democracy. And generally, briefly, I want to touch, this is work in progress. I want to touch on Carrie's work, the ABA Resolution 108 on civil discourse and lawyers' role, passed in 2011. The notion of collaborative governance, which is language that's used a lot these days in public affairs and political science not so much in legal scholarship, although Jody Freeman has used it, David Markell has used it, and then talk about this project in our community, Strengthening Democracies, in terms of health. In other words, local dialogue about health. And then talk about lawyers' role, particularly because my colleagues here at O'Neill, I'm the only lawyer left standing virtually. We used to have 5. There's one more who is a joint JD PhD, and he thinks of him, he does more economics. So getting people to control for law as an exogenous variable in their research is this ongoing thing. And getting all of us to think about not just process, but the rules that govern process is part of my personal mission statement. So Carrie, thank you again for everything you do and your generosity of spirit. And here it is, 2004, the last year the Hewlett Foundation was funding our field, and Carrie is writing about democratic participation. If democratic participation is the means for achieving both public order and social justice, lawyers have a role to play in such processes. And these are just chunks out of the middle of sentences, but I love that chunk. And then the 2006 chunk. So the first is lawyers' role in deliberative democracy. The second is deliberative democracy and conflict resolution, 2 theories and practices of participation in the polity. I love the titles. Perhaps it is time, and this is again the middle chunk out of part of a sentence. Perhaps it is time for conflict resolution professionals to learn some of the theory and practice of deliberative democracy, including methods of large group deliberations and social learning, in order to consider ways to scale up good problem solving. These are key concepts that we ought to be this ought to be part of the required curriculum for law schools. So in 2010, Bruce Meyerson and the section of dispute resolution for the ABA started a task force on civility in response to the shooting of Gabrielle Giffords and other people in Arizona. And it was all political, and it was a preview of what's happening now and what happened on January 6th. And this drafting was led by Richard Rubin at Missouri, but the committee included organizations. It included the Deliberative Democracy Consortium. Terry Amsler, my husband, was by then representing the Institute for Local Government at the California League of Cities, is now here at O'Neill and also working with our state equivalent of the League of Cities. So the ABA mandated that lawyers need to set a high standard for civil discourse, that lawyers need to take meaningful steps to enhance the constructive role of lawyers in promoting more civil and deliberative public discourse, that lawyers need to strive for a more civil public discourse in the conduct of political activities and in the administration of the affairs of government. And then they need to support government policies, practices, and procedures that promote civility and civil public discourse. So this question of civil public discourse relates directly to collaborative governance. Again, language being used a lot in the fields in which I am publishing in addition to law. And it's basically an umbrella term for a whole family of all these voice processes that we teach in public in conflict resolution across the whole policy continuum. So it encompasses public voice in the legislative, executive, and judicial branches. And I published this map a long time ago, but it helps you see where there are silos of scholarship about collaborative governance under different terminology. So upstream in the legislative and quasi-legislative, referring to the policy and rulemaking processes in agencies. includes public engagement, deliberative democracy. When we're in the middle of a public agency, the fourth branch of government, then we've got everything. We've got collaborative public management networks, public engagement, deliberative democracy, dispute resolution, although less actual deliberative democracy than one would like. And then downstream, we have what we mostly teach in law schools, which is dispute resolution in courts, in public agencies, negotiation, mediation, arbitration. So there is institutional design literature out there. We have a powerhouse of work being done at the Ostrom workshop here, but it doesn't generally get acknowledged or cited much in the law review literature. It is in our book. There is Jen and Stephanie's analytic framework for dispute system design. And in our book, we also talk about the piece of design on this spectrum that applies to public engagement processes. There are literature, there are articles, for example, the Institute for Environmental Conflict Resolution that was headed up by Kirk Emerson. They've written a book on collaborative governance regimes. Tina Nabachi, my former doctoral student. So here's the project we're doing right now. And it is being led by, I wrote the grant to the Robert Wood Johnson Foundation on behalf of SCHMOOZE. None of the money comes to the university, $650,000. They were funding 6 grants, 1 per state. 29 states were eligible to apply. 6 states got a grant. We got the grant for Indiana. And when they found out that SCHMOOZE had 1 employee and a $60,000 a year budget, they required that SCHMOOZE have a fiscal sponsor. So the Bloomington Health Foundation is our fiscal sponsor. But this is building infrastructure for local communities to empower voice of underserved communities, Black people, people of color, disabled or other abled people, and members of rural communities in Indiana, starting with Monroe County and then scaling it up statewide. Terry Amsler and I are co-chairs of the Statewide Partners Council. On our Statewide Partners Council, we have the Association of Indiana Counties. We have the Accelerate Indiana Municipalities, which is our state equivalent of the National League of Cities. We have the Indiana Minority Health Coalition, IU Health, HealthNet, and the community, the Center for Rural Engagement at Indiana University, the Program on Political and Civic Engagement, as well as the O'Neill School. So just to give you a tiny sense of what we've done so far, this thing started in April of 2020 in the middle of the pandemic. We had proposed in-person public engagement. We couldn't do in-person public engagement. So we ended up having to do this. We have had to do it on Zoom, although we have now gotten to in-person processes. So in terms of the infrastructure that we're building groups of underrepresented voices from the community, the diffuse public. So we're having deliberative democratic meetings where we're specifically working with our organization in town that is representing the Latinx community and with organizations and various stakeholder groups representing the Black community and getting volunteers to come to these deliberative democratic meetings with policymakers. So in other words, we've built an advisory council of members of government in the county and in the city, people who are working on the advisory council, along with the Chamber of Commerce, the United Way, various nonprofit organizations. And so that was phase 1. There have been these various dialogue processes, engagement stage 2, small group discussions, and then deliberative sessions where we're trying to get these problems in health. And we're talking about the social determinants of health, public health, health writ large, not masks, but everything. And I'll give you examples. So, and how many minutes do I have left? 2? So in terms of examples of social determinants of health, This is the big problem I want lawyers to start focusing on. Over the past 10 to 15 years, primarily Republican states have been passing statutes handed to them by ALEC, which do things that disempower local communities from passing ordinances in all sorts of areas that have to do with social determinants of health. So these are examples only from Indiana. Our minimum wage is locked to the federal minimum wage, which means no municipality in Indiana is allowed to pass a minimum wage law that is a living wage or anything higher than the federal minimum wage. Landlords, as of 2 years ago, cannot be regulated by municipalities. You can imagine how that made all the college towns in Indiana feel. Health insurance and benefits can't be in any way regulated or recommended by municipalities. The open door law in Indiana, and this is a problem in open door law and sunshine laws across the country, does not require a public comment period, and 70% of the communities don't have one. Now that we have virtual public engagement, there's a lot more participation, but the legislature has cut back on it by mandating that at least 50% of the elected officials must be physically present. So these are just examples. They're all over the place. So the argument here is that lawyers and ADR professionals are essential partners in community problem solving using dialogue and deliberation. We need to help people with institutional design. We need to help communities build that infrastructure for voice. It really doesn't exist in many, if not most, communities in America. And lawyers are best qualified to identify the ways in which legislatures are disempowering communities and act. So that's it for me. How many minutes are left?
Just tell us how many minutes we want.
4 minutes or less.
4 minutes for questions, comments, suggestions. And we'll start with people in the room, and if you can come to the microphone, just to make sure that people online can hear. And Carrie is approaching the microphone, so, because I think we don't have the camera on her. So,
Hi, Lisa. Can you hear me?
Yes, put the camera on Carrie. You don't need me.
You want to go to the podium?
go to the
Oh,
podium.
sure.
Yeah, and she can
Then
I don't want to hug up
everybody-
the whole 4 minutes, but.
Yeah, you can just talk.
Okay, oh, there I am. Hi.
Everybody-
Anyway, Lisa, just to say how important this work is, it's terrific. And you touched on the thing that has driven me crazy in this field, and that is the silos. So public policy schools like yours, you're teaching some of this stuff, and city planning schools are teaching on this stuff. And every other year, I teach a course in multi-party dispute resolution where we talk about all this stuff. And it's just so important. And I also want to thank you for putting up all those Indiana laws. It's just a horrible problem. I think my husband's a Democratic political consultant, so he's been working on these issues at the electoral level. And so my only comment, the project's terrific. So as you describe what you're doing in Indiana, I think it's so important to publish about this across disciplines. And I agree with you totally that this should be taught in law schools. You might just want to talk about the fact that some law schools are teaching legislation courses. So when I was at Georgetown, it was a required course in the first year for a short time. Harvard occasionally has done it. Columbia has done it. We now have it as an elective at Irvine, a course in legislation. And I just want to say those courses are taught doctrinally, like most things in law school. So, and when you're writing this up, just talk about that legislation courses are one place to teach this. And the important stuff is the skills part of it. As you said, lawyers are there to spot all these issues and to facilitate discussions. And I'll just leave you with a comment that's buried in the footnotes of a whole bunch of my deliberative democracy articles, just to think about. I mentioned at the end of my talk yesterday, there's an irony in our work because I started off, I think you've seen it, having this graph about principles, bargaining, and passions and ethics, different modes. I'll send it to you if you haven't seen it. Modes of conflict resolution. And I have all these examples, and one of them is Occupy Wall Street, which was supposed to be this democratic deliberative process ground up. And it failed because there were no leaders. So there's an irony in our work that we're talking about deliberative democracy. And as you know, because you spent your life writing about it, it needs leadership. and it needs facilitative leadership. And there's just an irony in that. You know, how do we deal with the fact that we are facilitating democracy, but it needs somebody to help manage it? Thank you. I look forward to seeing the whole paper.
Thank you. That was great. Thank you very much.
Bye.
Participants online, there should be a link where you could send additional comments, suggestions, thoughts to each of our speakers, and what will happen at the end is those will then be sent on to the speakers. So so please avail yourself of the link. I think it's just gone into the chat. So any and all thoughts, I know Lisa will appreciate them, and thank you, Lisa. Our time is up and we're moving on.
Thank you very much, Lisa. And I do encourage everybody to give your comments. This is why we're doing this, so that we can help people produce better scholarship and better work. Okay, so our next presenter is Kelly Browe-Olson, who is an associate professor and the mediation clinic director at UA Little Rock Bowen School of Law. She teaches family law, ADR, domestic violence, and mediation and family mediation seminars. She was awarded the Bowen Faculty Excellence Public Service Award in 2004 and 2013. Welcome.
Thank you. I'm going to share my screen briefly. Can you guys hear me?
Yes.
Okay. So I'm going to be talking about special education mediation, which is one of the projects that we do. And we also do facilitated individual FIEPs, or facilitated individual education plans or programs, depending upon what language you use. And I do think it's funny because sometimes they're called IEP plans, which would be individualized education plans. But and Nancy Welsh helped me to talk through some of this, and I'm going to be presenting on this too at Stetson in a month. So I've just started my thinking about how to write about this. But we've been conducting these mediations now since 2006 and in person. And this last 2 years, obviously, we've made this shift online. And I just have had some concerns. And I know Noam's written about this because I've been reading it in preparation for writing about this, about that. It can be empathetic online. It is empathetic online. I haven't personally seen it, and I'm struggling with how to get there, both with the procedural fairness in these and the substantive fairness in these. So, but I also have been just thrilled to be a part of this conference that honors Carrie. And I thought, well, she's talked about everything, but surely not special education. I mean, everything, but really special ed. But it turns out that, yes, of course, Carrie has talked about special education, because of course she has. So I found this online, and I was thrilled to see that this had touched her universe. And she talked about how you can have not alternative, which is the title in here, but if you get into, I thought it would be a bit plagiaristic to show the whole thing, though I was tempted to just stand up here and show her PowerPoint, was alternative dispute resolution that is actually appropriate dispute resolution in special education. I was thrilled to see that. And she even at the end of it, because she's Carrie and she's precedent, talks about all these other forums that it will be coming into, and talks about online, talks about the possibility of many things, including online. So I want to just do a quick background on this and then kind of open it up for even more questions about it, but tell you sort of what we're doing. We started doing special education mediations. The federal government forces states basically to have mediation options for parents, both before they apply for due process and after they apply for due process. And so we've been mediating for a long time. Like I said, Little Rock has had the grant from the Arkansas Department of Education since about 2006. And we've run the program the whole time. We go statewide. We have trained mediators that are trained in family cases, and then they have an additional 12 to 16 hour training that we do, because we find that these are really a lot about group dynamics, and they really look more like business mediations than your traditional family mediations. We started a few years ago working with Cadre, which of course Carrie cites in her PowerPoint, which is the Consortium on Alternative Dispute Resolution in Education up in Oregon. And they have, they're an amazing resource in this. But one of the things we looked at was a lot of these mediations are identifying what happens in the IEP and how the IEP is falling apart. And what if you could facilitate to create the IEP so that things don't fall apart, so that parents and teachers are on the same page. And the, sorry, I meant to set my timer here for time. So we now do both of these processes. We talk about mediation and we talk about facilitated IEPs with students and with faculty and with parents. And then we conduct these hearings, and we've moved from, not hearings, sorry, we conduct these meetings. We've moved from just doing FIEPs, the facilitation, the creation of them, to facilitating their adaptation, to facilitating the next IEP. And we found that especially parents that are in high conflict with schools like us to do them every time. So they like us to be there. And one of the questions we get often is, do I need a mediation? Do I need an FIEP? For an FIEP, the team has to be there, right? So a team, and there's a term for it, but it's the 5 people that are most important to this child's case on these cases. And they're really about what goes into the IEP. So one of the differences is when we have an FIEP, we do not create a memorandum of understanding because we want all the information to be in the IEP. When we have a mediation, we're creating a memorandum of understanding, and it's about what's happening that isn't working within the IEP. And sometimes, because life is confusing and gets messy, we do both in the same day, which has different rules, different guidelines, different agreements. Arkansas is a funky state. That would take more than 20 minutes to talk about all of that. But one of the specific pieces is that attorneys are not allowed in mediation in special ed. A lot of litigious attorneys in the early days before we started our program, and the Department of Ed just won't let them in, but they are allowed in FIEPs. So we frequently will have attorneys calling and saying, I need an FIEP. And when they discuss it, they perhaps want a mediation, but they can't be in the mediation. So we have an FIEP. So we have these issues. So just a little bit more about it. When we do the initial facilitation, it's hopefully not positional yet, not required by law. I already said attorneys can attend. It's usually the facilitation, even if it's a secondary facilitation, which means they already have an existing IEP and we're going to create the next one. There's not as many trust concerns as there are with the mediation. It's all voluntary. When I say mediation is required by law, that means that they have to provide the opportunity to mediate. Again, it is still voluntary. For facilitations, the school does not have to agree to have a facilitator there for the mediation. And it's sometimes surprising to me that schools don't want facilitators there. But the schools that have had us there usually invite us back within the next 2 weeks about another case, which I think is interesting. So that's some of the basics. I'm not going to go through all of these details, but just to talk about that there are different processes here. Then when you have formal mechanisms for resolving these issues, again, Carrie talked about this, that there are different levels that you can look at. And so there are procedural and substantive places where the parties can go to when they have issues. And so what are you might, if you don't know about this area, you might wonder what some of these issues are. Well, if children have been found to have special needs, there's usually a doctor's diagnosis or some kind of provider's diagnosis. It's not necessarily the same as what the school will provide. And a school only has certain responsibilities to provide a fair and appropriate education and in the least restrictive environment. And what happens is, just as an example that just happened about a month ago, is we have a development center here that does testing, and they provided a plan for the child that included, this is a child in a more rural district in Arkansas, that would have the child needs 25 hours a week of therapies, occupational therapy, physical therapy, and speech therapy. This school district has therapists there total for the 200 plus students for 40 hours a week. That's their total amount of hours for all of the students. And so there's a conflict, and there's a difference between what a doctor diagnoses as something that people need to work on, and or as the student needs help with, and what the school's therapists and providers think that the child needs help on. And so there's conflicts about this. There's also conflicts about what it means when the child needs an aid or things like that. So these are all kinds of processes that the parents can go through to get what they want for their child. And what the states have found, and the reason that mediation is important here, is because sometimes there's real conflicts between parents and schools, but there's real language issues and there's real translation problems. And so we can help with that. Mediation also saves states a lot of money. It can cost anywhere from $30,000 to $45,000 to have a due process hearing. And so the states like to do this. We don't charge anything, which helps. It comes out of the budget. It's a federal pass-through through the state. But sometimes even the teachers and the schools are reluctant to participate in this, as I said, until they've done it and a couple of times at least, and then they do like it. But my concerns go to, I'm sorry, and this is another slide. This is from Cadre about the continuum of all of the things that are available to parents that are going through this, and what level of intervention is needed, and how Cadre has identified the best process to do this. And what we found is that there really are distinctions with what schools know about what the law is and what they have to provide, and what parents know, and what perhaps parent advocates know, which is another issue, or think they know, and what someone finds from looking up the law, maybe a NOLO, some kind of online law service that will tell them. There's just a lot of misinformation and disinformation out there for the parties. So obviously this is a lot of background. All of these people can decide what it looks like, what the process is. And I'll tell you that this information that we try to get out to a bunch of different conferences and parties and through the disabilities rights organizations in the state, people still don't know exactly what they're entitled to and how it works. And that could be an issue. So family engagement is important. This is a little look at the costs. I'm kind of blocked from looking at this. So this was the settlement prior to the due process hearing and those other pieces. Okay, I think that's it for my slide, so I'm going to stop sharing. So that's the background information. So what I'm looking at is when we've been doing these, and so for the past 2 years, we've been doing them online, and we had a quick pivot to try to get them online. And now what's interesting is now they're hybrid. So we'll have some people that want to appear online and some people that want to appear in person. And what I'm really trying to gauge is, are we doing as much to get people the law and to get people the information they need, and to make sure that the process is working for the parties online as we did when it was in person. Now, I'm not saying it was perfect when it was in person. And one of my famous quotes that people at the school get nervous when I say is, I can't wait till we stop getting this grant and I can sue the Department of Education for all the things they've done wrong. But I think that there are issues even within our program, and we are really limited, right? Because we're the neutrals in this program. And so we can't give people advice. We can send them to advocates. We can suggest that they do certain things. We can suggest, as happened when a mom called us about a 5-year-old who the principal told her if she didn't get him on ADHD meds, he was going to file a FINS petition against her, and he probably could because his brother-in-law was the judge in that town. That we're really hampered on what we can do, and the overlap that sometimes goes on, that would be a whole other presentation, between juvenile issues and dependency neglect issues and special ed issues is really alarming. So that's where I'm basically starting from. I don't know how much time I have left. How much time do I have left, guys?
7 minutes.
7 minutes. Okay. So I'll just say one more thing and then ask for feedback is, so there's a bunch of different pieces to this. And before I get to I can talk about the procedural issues. I can talk about my procedural concerns. I can talk to you about how I spent half an hour on the phone the other day with a mom who said she just really wanted to come in online because she's afraid of the conflict with the school, which has existed, but it's not a COVID thing. She's not afraid of being there in person. She just doesn't like it because it's conflict. But we've had 3 or 4 where we had some people online and some people in person, and the mediators didn't like it. The parties came out with their reviews of it were much more negative than they were when everybody was in person or everybody was online, especially when, so picture this, you've got the facilitator and all of the school personnel in a room, and you've got the parent coming in on Zoom, and being able to talk through these things, or being able to caucus and talk to the parent individually, it changes the dynamic. And we really have seen, my mediators and I, we do quarterly reviews, and of course they call me all the time too, but a lack of empathy on the part of the school when they're in person, when they're online, and a lack of empathy for a parent when the parent's online and it's only the school in the room. So with that very basic presentation, I'm open, and I'd love to see if Carrie has thought any more about this since her presentation in 2017. So thank you.
We're looking at Carrie. If you have something to say. Carrie's approaching the podium.
Thanks for the play-by-play, Cynthia.
It's a terrific project. So I can't believe you found those slides. I did special ed cases at the beginning of my career as a parent representative. And then I've spoken with cadre many times because of the mediation process, and worked on their training programs a little bit. What you're doing is terrific. When you finish, let me know. Let me share it with my students. I have several students that are working on ADR issues in special ed in California. A little better resource, but not great. I just found your last comment really important. I'm sitting next door to Rabinowitz Heine. The mode of dispute resolution is becoming so important now. So we who all talk about process pluralism, how do these different modes interact? And in another thing, I just wrote a big article about the book chapter on hybridization generally. And you just indicated another whole form of hybridization these days. That is, what is when the parties are not in the same mode? And everyone in this room has either been a student or a teacher, knows what that's like. And almost all of us, like the people you're talking to, say we hate that hybrid thing. So it may be better in some cases to stay all online or to be all in person. And I think your project could talk about that. And then, of course, eventually we might need legislation or something to permit that to happen, because so much a part of conventional conceptions of due process are right to confrontation, obviously in criminal law, not special ed, but people have an expectation. Some really want to confront, and the story you just told about the mother who doesn't want to go to the school, I completely understand. So, and other people that are here, other online or in the room, and you know this because I attended some of the mediation clinic workshops that have been going on for the last 2 years, and there's been a lot of talk about the people who prefer online, with breakout rooms being, making it easier to have separate caucus sessions. And I, Orna knows this, I started as a big skeptic of online stuff. But in some high conflict situations, a lot of the mediators described that it was actually very mediational to reduce conflict by not having people face to face, which was never my preference before. But I learned to change. So, this is just a long way of saying I think this project is just really important. And the only thing I would say is, to the extent you can find out from other states what's going on, that would be really helpful, because I know I have 3 students writing papers on this right now. And even within a state system as big as California's, there's an enormous amount of local variation. Stories you tell about smaller towns and where the hearing officers are. And then I have to, I hate to say this, I'm not a fixed pie person, right? But you describe fixed pie situations. There are limited resources, and how are those being allocated? So that's a substantive concern. But the project is just really, really, really important. I have just one other, this is my only critical thing. So I worry about this, is the lawyer in me. So I totally agree. I don't know if Lisa's still on the line. As some of you know, I've written very controversially about the importance of being a lawyer in all of this ADR stuff. It's still very important.
Yep.
Because I worry in some of those less less formal in mediation settings in the efforts to build relationships. The lawyers in special ed that my students interviewed for a paper last semester said that the lawyers have the repeat play relationships with all the special ed decision makers. And so it's not unlike public defenders stuff, right? The public defenders interact with the prosecutors all the time. And so they can have this little clubby thing, which can get things done. But in some cases, I fear that the parents aren't getting, funny coming from me, right? The parents aren't getting good, I would say either adversary representation or, as you described it, getting full information.
Yeah, Carrie, I think that's
things they want to make deals.
Yes, thank you for that. And I would love to see your student's paper because I'm sure it's excellent. And I think that is a really valid concern. An interesting twist on that is that 2 of our mediators serve as due process hearing officers. And so we have the repeat players a little bit on our system that see the what happens on the other side of that, which I think is a bonus. But is also a bit of a conflict. So they don't obviously handle a mediation in a case where they see it as a due process, but it is interesting. And I've tried to twist arms to get them to have lawyers, but it is something I will tell you that the cases I see, the school and the parents mix up the law equally as much because both of them don't have lawyers there. But the school could still have lawyers behind the scenes. And Lisa in the chat mentioned Nancy's article, which when I talked to Nancy about this and she helped me to get ready, she asked me if I'd read it. And I said, not only do I read it, but I assign it to my students every semester because it's a really good foundational article about what parents are thinking in these special education, processes themselves. So thank you for your comments.
So thank you. And once again, there's a link in the chat. Please send Kelly comments. As Kelly said, she's going to be presenting this at Stetson's. This is very much a work in progress. Our next speaker is live and in person. So speaking of our hybrid processes here, and Peter will do the introduction, but just to be aware, Bob, look across from you. There's going to be numbers coming up right here. She'll hold up numbers so you'll see what the time is and when the time is up. So, okay, Peter.
So thank you so much, Kelly. So our next presenter is Bob Probasco, a senior lecturer here at Texas A&M University School of Law. He directs the Tax Dispute Resolution Clinic. Prior to joining the law school in 2016, he spent 15 years in private practice, and he also wrote a chapter in the ABA published book called Effective Representing Your Client Before the IRS.
Good morning. I'm a little bit intimidated about this because I'm really talking about the interaction between ADR and clinics, and Carrie's in the audience, so that's intimidating, but hopefully I will get some good feedback. I titled this for purposes of the agenda, whether and how to incorporate ADR into the clinic classroom. It's not about incorporating ADR into the clinic. That must happen inevitably. It's really talking about to what extent we can and should and how we should incorporate it into the classroom seminar. The decision about that is not going to be the same for all clinics. Obviously, not all clinics involve dispute resolution as heavily as mine does. Certainly, we do have an existing ADR survey that all the 1Ls are exposed to some of these concepts. And of course, we have limited scope in the classroom because we have a lot of other things we have to cover. I have a very complex area of substantive and procedural law that I have to provide to my client, my students. And we have administrative requirements of the law firm that a clinic is. And of course, we have case rounds. When I first started out at the 24 class sessions during a semester, about 10% of those went to general skills. Everything else, interviewing, written advocacy, narrative and storytelling, fact investigation, client counseling, cross-cultural competency, and negotiating, since that's the part of ADR that we use. That is now up to 25%. Over the past 5 years, it has evolved. I've added a few skills that I didn't talk about in the classroom in the early days, spending a little bit more time on some of the particular skills and adding some exercising. I chose to increase the emphasis in the classroom on negotiating, primarily because of a concern about what I was seeing from the students. Specifically, in my particular practice area, it may not apply to all clinics. I saw something that I thought was students crossing, kind of blurring the line between dispute resolution and compliance. And it's a big risk, particularly in tax, I think. In tax, we almost all are familiar with compliance, and you put it on a standard IRS form that Office of Management and Budget has approved, and everybody sees them. We also use standard IRS forms for a lot of our dispute resolutions. So you're filling out a standard IRS form, you're mailing it to the IRS, and that subconsciously can feel like compliance. I'm just filling this out. Instead of, I am making the opening argument in a negotiation, which is what it really is. There are also concerns because students are coming in and they are not negotiating for our taxpayer with other taxpayers. They're negotiating with the IRS, and it's very easy to think, oh my God, the IRS, they are the tax experts. They must be right. And they're not always right. And they also can sometimes look at it and think, the government is making the decisions here. We're used to the government making decisions. And I have to get across to them that in our work, the IRS is not the judge and the jury, they're the opposing party. Now, sometimes we don't have access to a judge, in which case they do de facto become the deciders, but hopefully we at least have that opportunity at some point in the process. So as I was seeing all these things and also some things about negotiating with the IRS that make it exceptionally difficult and different from probably what a lot of the standard things we think of as negotiation, I thought it made sense to emphasize that a little bit more, still within the constraints of I've only got 6 classes to cover a whole bunch of general skills. And I'll get into the things that make working with the IRS a very difficult negotiation in a bit. But the question became how to incorporate ADR into the classroom. In the early days, I was combining it with other skills into a single class session. And I was approaching it, this is a rookie mistake, I admit it, I was approaching it more from a theoretical or abstract perspective. That was an incredible rookie mistake for 2 reasons, I came to believe. One is, I don't have an extensive background in ADR, like our ADR faculty. They have engaged with these issues for years in a very complex and deep manner that informs their discussion and lets them bring more to the discussion than I was really bringing, because I could read something in a book about some fundamental concepts and I could throw them up on a PowerPoint and I could talk about them, but I couldn't really add as much to them just reading that themselves. So I decided I needed to redo that approach, and we did that about 2 years ago, which was about the same time, I think, that we changed the name of the clinic. The clinic used to be Low Income Tax Clinic. What does that sound like? To a lot of people, including students, I think, oh, low-income people, they can't have disputes or anything. You're probably just preparing their tax returns. Compliance, and no one would sign up for the clinic. I needed to make it clear that that's not what we did. And some of it was in the description of the course, but we changed the name of the course. It's no longer the Low Income Tax Clinic, Tax Dispute Resolution Clinic, because that more accurately describes what we do and also avoids the mistake that some people were making when they looked at us to think, well, even if if you're dealing with low income taxpayers, they can't have complex problems. They probably don't have any problems at all, but if they do, they've got to be pretty simple, don't they? And no, they don't. You're doing some of the same things you would do with some of the very wealthy taxpayers that I used to represent before I came to Texas A&M. So we decided to change the approach. I started off working with Professor Riley, and we threw around some concepts and ideas, and this is what we came up with. And this is something that it would be valuable to get feedback on other ideas that we might want to consider, because this is an evolving, if you're in a clinic, you should be evolving every semester, and we will continue to, we discuss every semester, is there something we want to tweak a little bit. But we take an entire class session, an hour and a half, solely for negotiating. Professor O'Reilly and I co-teach it. He knows negotiation. I have experience dealing with the IRS actually negotiating. So I was able to learn a lot from him, and he was astonished, sometimes horrified, when he heard about some of the things negotiating means when you're dealing with the IRS, which we will get to in a bit. We assigned, I only really assigned one reading before class. That was something to kick off some discussion, but we were going to be just branching off. No one knows where we would wind up any particular semester. Obviously, if you go out and look for something that you might want to use in a clinic to get students starting to think about negotiating, I would guess that if you look around 20 different places, at least 19, maybe 20 of them will recommend the article that I wound up assigning to my students, which is when winning isn't everything, the lawyer as problem solver. And it has a lot of really great discussion. There are things in it that don't apply well to our clinic, but there are other things that are great. And the primary thing is it gets students thinking about changing their entire mindset when they're going into this. The structure that we have is it's a little bit informal. We start out with a participative kind of a roundtable discussion about the article. What did they learn from it? And bring up specific points and get some discussion going back and forth, and try to get the student, really draw the students in on that. Then I describe the peculiarities of negotiating with the IRS, and continue to astonish and horrify Professor Riley every semester, I think. Because it is very, very different from what you might normally think about. And I'm going to, with some time at the end, get back into some of those things. And then we turn the rest of the class session, Professor Riley takes the lead in discussing just general topics about negotiating. It may be different from a practical perspective. It may be different every semester. And a lot of times it just builds upon what some of your earlier discussion has been, either in my presentation about the peculiarities or in some of the things that came up in our early discussion. In this semester, we got into a good discussion, I thought, about not only establishing relationships, which is one of the peculiarities I'm going to get to in a moment, but also the idea of empathy, which is also in Carrie's article. You have to negotiate with someone, you have to understand where they are coming from. And we talked about that for quite a while. We got into some discussion actually of the ideological Turing test. That is a concept that economists suggested once. I don't think there's been necessarily much scholarly work done on it, but it engendered some good discussion. I think at the end of the class, what we come out with is people have some ideas or thoughts that they didn't have going in necessarily. In all of clinic, we are really for these general skills, whether it's interviewing or counseling or narrative and storytelling or negotiating, we are trying to move them a little bit further along than they were. We don't have time for a full discussion to really bring them up to master level, but for that, we have the ADR faculty, and they certainly can do that. And some of my students have gone over and taken courses. And I have some time left, I think. So I would like to talk a little bit about how negotiating is different in tax dispute resolution. Partly, one of the hardest things for the students is that the IRS is the toughest kid on the block. It's a huge government agency. They have leverage under the procedural law. They can do very, very bad things to taxpayers without going to court. We have to go to court to stop them. So they have huge leverage. There are silos within the IRS, and we may, in the course of a single representation, have to deal with 2, 3, or 4 of them. We may be dealing, and they all have different responsibilities and goals. We may be dealing with the audit group. We may be dealing with the Independent Office of Appeals. We may be filing a case in tax court, in which case we're probably not going to trial. I have my second trial coming up 2 weeks from this coming Monday. It will only be my second tax court trial ever. We negotiate with IRS attorneys. We may be dealing with collections and trying to persuade the IRS to accept less. So we have to deal with a lot of different groups. And they are spread out all over the country. We're not dealing with people in Dallas, Fort Worth. We almost never do, except for the IRS lawyers. We're dealing with people in Fresno. We're dealing with people in Memphis. We're dealing with people in Cincinnati, in Holtzville, New York, all over the country, which means we have very, very, very few repeat interactions. And that in itself is a huge burden that we have to deal with. Our method of interaction is almost exclusively written communication. We have some phone communications. In person is very, very rare, and that makes it very, very hard to do. You don't have all those visual clues. In some functional groups, even though you're dealing with this group, you're dealing with a different person in the group every time you contact them on the same representation. You're representing Mary Jones. You call today, you talk to Jeff. You call 2 days later, you're talking to Joan. And they keep notes, but you're not even talking to the same people. And you're also talking with a lot of people that are relatively low level. They have not been very well educated or trained. That leads to some rigidity, along with transparency. They will tell you, this is how you're going to convince me, because I've got a checklist that the supervisor has given me. And some of those groups, it's very hard to move them off of that checklist. The timelines, sometimes they are very long. They may be over the course of 3, even 4 years. Sometimes we have speed negotiating. This is one of the ones that astonished Professor Riley, where I meet the client and I have 45 minutes to find out everything I can from the client and then try to negotiate with the IRS attorney before the judge calls us back, which is exceptionally challenging sometimes. But you get some adrenaline that way as well. We are a stereotypical zero-sum negotiation because we're talking about money, but they're not focused on split the difference. You can't go in and they say, You owe 20,000. Well, would you take 15? No, maybe I take 8. They don't do that. They focus on what is the right answer, but they usually will take the right answer even if it does not maximize in revenue. So it's a challenging environment, but a fun one. But it's difficult at times figuring out how to adapt normal negotiating principles to that particular context. And with that, I will stop, and I would love suggestions or advice on how we can do it better next semester.
Can I just say one quick thing, just how much fun it has been to go in and work with Bob on this course. And it's been a real collaboration. I know nothing about tax, sort of procedurally or substantively, but the bridge has been Carrie Menkel's article. And what you find is, this is just, when I looked at it, it's like, well, this is a situation we got to go in, and it's two people talking and trying to do problem solving, right? And so that's what her article is about. And so it really has opened my eyes to this idea that these theories and principles apply to so many areas. And even if you think it's some technical area that has nothing to do with ADR, it really, really does. And so thank you, Carrie, for writing this article. It has been a bridge for me to bring sort of the stuff that I know into this class. And it's been a real joy to work with Bob as a collaboration. So with that.
If I had asked Peter before I did all this, he would have told me that would be a great article to start with. I actually picked it before I even discussed it.
That's what I love. When I said, what article are you using? And he said, Carrie Menkel-Meadow's article. And I said, I'll work with you. So with that, if we could have Carrie comment.
You want me to come to the mic?
Yeah,
Yeah, it's the
please.
microphone here. Yeah, we've got the one that's set in the audience. So sorry for those in the Zoom.
I love this project. It's just fabulous. So for everyone out there in Zoom land or here, at some point, I wrote an article called Mediation 3.0, but what you're talking about is ADR 2.0, which is, I'll talk about tax in a moment, which I happen to love, believe it or not, yep. But anyone who's here who also teaches any substantive subject, this is an argument for ADR being taught pervasively throughout the curriculum. Because what you're talking about, this is a sociologist in me too. All of these ADR concepts have to be adapted, just as you ended, Bob. They have to be adapted to the environment that they're in. And so here at Texas A&M, big plug for you guys, having ADR somehow in the first year, or for some of us in civil procedure. And then for people teaching substantive courses to pull out those concepts and to say, how do they work or not work in this particular substantive area, and why not? And how can we take the idea of problem solving or whatever and adapt it to the particular environment? So it's amazing. And I don't know if you know this, but we have a new tax LLM program at Irvine, and I don't think they're teaching any skills. So you have inspired me, Bob. I'm going to go back and yell at those guys, and they're really good tax professors, and it's all about the substance. And so I have a couple things to say about tax.
So Carrie, I'm sorry to cut you off, but we're at the.
Oh, no.
So you and Bob can speak at the break.
Okay.
So you can give him all your wisdom then.
Thank you. And you're doing all the right things. And I just have to say to everybody now that, as you say, empathy, the other side, what motivates the IRS people on the other side? How can you appeal to them? And when you get those people, I have it all the time, that are rigid at the bottom and are following the rules, they've been taught to follow the rules. Classic thing, how can you teach students to climb the ladder? It's very hard at IRS, very hard at Amazon, it's very hard at any big organization. But if you're negotiating with someone and it's not working, figure out what to do. Now, I don't know if it works with IRS so much, but sometimes you just hang up and start all over again. I know you can't do that so easily in IRS, but one of the things with these big organizations is how can a less powerful person choose their negotiator? I do with airlines all the time. I get someone who's doing the rules. There are rules, and I don't like what I'm getting, and I will just start all over again. Anyway, terrific work. So we'll talk some more during the break.
Thank you. Okay, so moving along.
Okay, thank you very much, Bob. So we're moving, our next presenter is Ulla Gläßer, is a professor of mediation, conflict management, and procedural theory at the European University Viadrina, Frankfurt, Germany. Her academic teaching and research covers the following subject areas: mediation, conflict management, dispute systems design, civil procedure law, private law, contracts, torts, and family law. Welcome.
Hello, everybody in Texas and in Zoom land. Hello from Germany. So we're turning international now, both because I'm sitting in Germany and because my subject matter I'm going to talk about is quite inter or transnational. I'm very happy to be able to talk to you. Thanks to Nancy Welsh, who has invited me. And I've happily said yes to the invitation because I think the research project that I want to talk about today is connected to the work of Carrie Menkel-Meadow in various ways. And Carrie, you know that your work has been highly influential for ADR scholars in Germany and other European countries. I will talk about grievance mechanisms along supply chains, and the parties in these mechanisms are transnational corporations on the one side and victims of human rights violations on the other side, or NGOs who speak up for the environment. And so we have a conflict constellation with structural power imbalance, where the state courts often fail to provide for protection, and dispute system design steps in with ADR procedures to provide for some kind of access to justice. This is a highly political issue in Germany right now because we have legislation in almost every European country coming up and a European directive. And the role of ADR in all this is disputed and very controversial. So our research project, and I start now to share my slides, has been commissioned by the German Federal Ministry of Justice, and it was a kind of Trojan horse. So I'll start with politics. We had a deadlock in the regulation, in the making of the new supply chain law, because there were different parties governing different ministries, and they just couldn't get to a proper draft of due diligence legislation. And so the Federal Ministry of Justice stepped in, and they commissioned a research where it was about ADR procedures, out-of-court procedures, and they said, this is non-suspicious. They will just let us do this, but we can move some things forward. And even if we don't get the social auditing laws and the top-down approach, maybe by creating a good access to bottom-up grievances, this can raise awareness in the political landscape, and ADR can have some positive impact. So that was kind of the background of the project. And we have worked on that project for 2 years. It is in a way finished. We handed in a 500-page report, and you have seen the executive summary translation in English, but it's still a work in progress because we have identified so many follow-up research questions. And this is my premiere talking about the project outside of Europe. We have presented a lot within European political and civil society frameworks in the last months, but not in the US. So thank you for listening, and I'll start to explain. The background are the UN Guiding Principles on Business and Human Rights. You might be familiar with them. They have 3 so-called pillars: the state duty to protect human rights, the corporate responsibility to respect human rights, which is soft law, obviously, and third pillar, access to remedy. And within this third pillar, there are 4 types of grievance mechanisms that should work together as a comprehensive system if the UN GPs are followed. So we have state-based and non-state-based, judicial and non-judicial, and our research project is situated here in the yellow lower quadrant. The UNGPs have 8 effectiveness criteria for these non-judicial grievance mechanisms. I'm not going to read them to you, but they are quite ambitious and at the same time very abstract. And they have some internal paradoxical things. For example, they should be rights compatible and at the same time based on engagement and dialogue. So you cannot have a pure mediation proceeding because somebody has to take responsibility for the rights compatibility, which is cannot be the weaker party. So one of our tasks was to specify these 8 criteria and to translate them into a working procedural design. How did we go about that? And that was a quite interesting research journey for our team. First, we started with a documentary analysis looking at selected already existing grievance mechanisms with their strengths and weaknesses. And I'm not going to read this to you. We look both at company-based grievance mechanisms and grievance mechanisms by multi-stakeholder initiatives, by investment banks, by NGOs who had created grievance mechanisms in South Africa for mining, for example, bottom up. And we analyzed them, and we came up at the end with a comprehensive system of design criteria, 32 altogether, who were meant to give the sketch for a blueprint, both for analyzing existing mechanisms, but also for designing a new mechanism from scratch. And we covered these 4 areas, not only procedural design, that was the initial idea of the ministry, that we should just give a checklist for procedural design, but we soon discovered that you cannot talk about procedure without talking about institutional level, which organization carries the procedure, how is this organization financed, what are the governance and decision-making processes, etc. How is the procedure implemented on the ground in the countries where the production places are? Is there outreach? Is there power balancing? Do the labor relations work there, or are unions illegal, for example? There are a lot of questions that concern implementation. And how can they all work as a learning system? So these 4 levels came up, and this made the report grow and become much bigger than we initially had thought of. This is the checklist or the design criteria, and I just want to point out some as examples. So for example, we asked ourselves how the funding schemes of the carrying organization influence the mechanism, and how can there be an independent organization serving all parties equally. They need material standards. Human rights are very abstract, so you have to specify, and you have to make these material standards work within the procedure as criteria for a conciliation process, for example. Looking at the implementation, we looked specifically how the grievance mechanisms can work together with other mechanisms designed to strengthen human rights, and I'll talk about that later. But also we found that there are conflicts within the supply chain. So there's a lot of pressure by the order, if you go downstream, by the ordering corporations, and if they don't give space and resources to the suppliers to adhere to certain standards, then it becomes like a nightmare actually, and the standards don't work anymore. So you need conflict resolution processes along the supply chain, and not only at the end with the workers or the environmental organizations. These are a lot of criteria, 17 altogether, that are important for the procedure itself, starting with admissibility questions. A lot of power balancing needs to go on here, and how to provide for specifically vulnerable groups protection of parties and witnesses. And well, we ended up with a hybrid procedure. I'll show you in a minute. And we studied how a learning system can really work, both in terms of internal learning, feedback, and working with the feedback, and also a public reporting system. So next step, within the system of design categories, we identified a lot of good practice examples from the mechanisms that we analyzed, and made a catalog out of these. And we interviewed experts from various stakeholder groups to counteract the suspicion that some sounds nicer on paper or on the internet than it works in reality. So we tried to do some kind of reality check. Due to the pandemic, we could not travel to India or Bangladesh or Mexico to really look at how the things work on the ground. That's one of the next steps. In the end, there came out this 500-page paper with 10 chapters. And our conclusions, findings, and recommendations, we decided not to put in an abstract way, but to create like a prototypical system, the integrative grievance system that shows how these levels of institutionalization, implementation, and procedural design have to work together in order to really give a good option for protecting human rights via ADR. Because there has been a lot of criticism by the NGOs in this area that human rights, ADR in this field is just it doesn't really work. It's more a matter of avoiding the courts and avoiding really good protection. And we think there can be a complementary system. I have to jump some of the slides, but maybe we can discuss them later. So you know, you are ADR experts as well as I am, that these mechanisms are not alternatives to the courts, but a complementary system. They have to work together with the court system wherever the court system works well. Due to corruption or due to financial hurdles or a whole set of hurdles, often the courts are not an option for the victims, for the affected persons. Some ADR typical things have to be balanced out a different way because the parties are not on eye level. So there have to be some measures for power balancing throughout the procedures. I'm not talking about the power asymmetries because I think your fantasy, your imagination will be enough so that you can imagine the weak position, especially if the trade unions don't work on the ground or cannot work. We have opted to recommend cross-company mechanisms rather than company internal mechanisms because these mostly appear to be closed shop or black boxes, and people were very dependent on the company internal mechanisms. So if you have a cross-company or a multi-stakeholder carrying organization, there's a lot of power balancing and peer control possible. And it's more efficient because the professionals who work with the process gain experience much faster. This is how the integrated grievance system is embedded in other mechanisms for promoting human rights, capacity building, social dialogue, and social auditing, and they all have to work together. So that's definitely a level of systemic work that needs to be strengthened because in reality, often these mechanisms just work parallel, but they are not interconnected. And we need decision-making organs that are including unions and including NGOs and not only governed by the corporations. We have devised for a system as well because we have invented or recommended 3 tracks. For one track for disputes between the companies at work or affected third parties, one track for companies and suppliers along the supply chain, and a third track for intra-institutional disputes between members of the governing organization. So if there's questions of adherence to the standards or if somebody should get sanctioned, that's a different type of conflict. So these 3 tracks have different procedural designs behind them, but I'm going to talk about track A. I'm skipping that because we focused on a hybrid procedure of mediation and arbitration. And in the end, this procedure looks like this. The dispute should enter a conciliatory mediation where the interests are identified and ideally the parties come to a binding agreement by themselves. If this doesn't work, the mediator can change head and make a conciliation proposal. In German, we call that Schlichtung. If they accept, then we have a binding agreement. If they reject the conciliation proposal, the complainants can opt to go into arbitration and get a binding award by a different arbitrator. And this is very important so the affected parties know that there's an end to the procedure because many NGOs, human rights protecting NGOs, complain that these ADR procedures are dragged out over years and they eat up a lot of resources. And at the end, everybody's exhausted, but there's no result. So you need to make sure that there's a certain point of result, or the complainants can opt out and go back to the state courts. There are a lot of provisions for counteracting power imbalance in our system. I'll skip these now and wait for questions. And we have devised for a learning system on 3 levels. First of all, the mechanism has to learn and optimize itself because right now the supply chains are very long. They meet very different conditions on the ground in different continents, in different sectors of industry. And so they have to be adaptable and learn continuously to provide a good service to the people there and not just to kind of carry out a blueprint. The second level is that the carrying organizations shall learn about human rights standards and improve their due diligence processes by getting informed. Every grievance is an information source to make the due diligence process better and more precise. And if you have public reporting, you can identify hotspots of human rights problems or environmental problems. And so there can be societal learning in the host countries and the countries which host the transnationals. So the reporting is very, very important, and there should be more precise and maybe not anonymous internal reporting to the members of the carrying organization of the mechanism, and external publicly available reporting to have the general public and democratic control in place. And there are good examples in German consumer conciliation that have governed these kind of reporting processes quite specifically. So there could be some transfer, at least for German lawmaking. I'll end with politics again. We now have a supply chain law in Germany, and it mentions grievance mechanisms, but it's very unspecific. And we believe that we need a better and more specific quality assurance, quality development, and criteria in the law, because otherwise there's the danger that it's too soft. But the corporations then say, oh, we did something, you see it, we have something in place, but it doesn't really work. We need to finance further research, especially now with the focus on the effects on the aggrieved parties and the sustainability of solutions that are found. And we think learning communities are very helpful, and people start now. They work with our report in different sectors. We have discussed our report in clothing sector, shoes and leather, car production, and these sectors start to talk to each other now and about best practice. And it spills over now to investment, the environmental area and climate funds, and they all now start to establish these kind of ADR procedures in one or the other way. Yeah, you can read more about that. Our English translation is still underway. 500 pages takes quite a while. And we are very interested now to start and to get into the English language discussion, and also publish parts of our report in US law journals. So if you have any recommendations, which journal would be the best for our results, let me know. Thank you very much.
What's our time? 2 minutes. We have 2 minutes. Time for one question.
Or comment, or do you
Or comment?
want to say something, Carrie?
She didn't know she was like the assigned commentator on everything.
You can come over here.
Terrific work.
Yeah, you want to come over here?
Oh, sorry for that. A terrific project. I assume you know the work of Naomi Kurzfeld, who's a German working in England who has done comparative studies of ombuds systems. And I went to a terrific conference that she ran at Oxford some years ago, and she's published on ombuds systems for disputes like this. So if you don't know her, let me know. Just send me an email and I'll send it to you. To answer your last question, I would think that the Harvard Negotiation Law Review, which is a regular law review, would be a terrific place for you to send your work. Although it's called the Negotiation Law Review, they're actually become one of the leading law reviews for dispute resolution generally. Also, Ohio State's Journal of Dispute Resolution, and Missouri has one also, which is just called the Journal of Dispute Resolution, but it's out of the University of Missouri Law School. I just wanted to comment. I love the idea here of talking about cross-company processes. A lot of us have been working on internal company forms of dispute resolution, whether it's online customer service and all of that. And for us, obviously, in the United States, where I'm in the middle of a course, not in the law school, but on antitrust policy, just with some retired antitrust lawyers. And, you know, there's a lot of talk here about, and you'll see in our Congress trying to regulate Amazon and Microsoft and all the really big tech companies for antitrust law because of so many customer complaints. I've been looking a little bit as a non-expert at the supply chain problems. I live in the middle of the port of Los Angeles, where we watched during COVID the buildup of 30 shipping ships during COVID that couldn't come into Long Beach port. So there will be enormous, there already are, enormous supply chain disputes internationally, but I actually physically get to see one of them in my own neighborhood. So my question would just be, if you know, you've written your report, this is a wonderful system of transnational law, which is something I taught a lot in London and in Europe. And I just love the idea of looking at transnational ADR. How are we regulating these big multinational corporations? And if we can't regulate, how does having an informal system help? So reporting and data. And the only question would be, you know, how do we enforce any of this? You in Germany are so much better at documenting everything than many countries. And the US does a pretty good job too, and so does England, but UK, at least it used to. But what do we do when we have different cultural, and that would be corporate culture too, processes for recording. So I love the idea of trying to do this transnationally. And the question would be enforcement. How do we do that? Thank you.
Thank you.
Good luck with getting it published. I think it's really important.
Thank you. Our time is up for this presentation. Please send comments to Ulla on the link. If you've got any thoughts or suggestions, please send them to her. And Ulla, I think you see there's a few comments in the chat for you also. So please don't overlook those. We're going to take our 15-minute break. So even though we got started 5 minutes late, we're going to give you the full break. So let's have our 15-minute break. We will reconvene at 10:45 Central Time. So 15 minutes.
All right.
Okay.
We're back.
Yes.
We're back.
So we've got one conversation going on in the back of the room, when in fact we're having a conversation in the front of the room. There we go. Which is wonderful. It means everyone's been engaged by the presentations we've had so far. So we're gonna move along and turn it over to Peter for the introduction.
Okay, great. Our next presenter is Janet Denton, and Janet Denton is director of the new dispute resolution program of Tarrant County. In her private family law practice, she utilized collaborative law and other forms of ADR to guide families to resolution outside of court. From 2009 to 2021, she served as director of family court services in Tarrant County. So welcome.
Oh, you need to unmute.
Unmute. Oh, the loveliness of remote and virtual. Thank you all so much for this opportunity. I'm a little stunned at being graced in the presence of all of this amazing work that's going on. Carrie's influence clearly has made its mark and will continue to do so. And what an exciting 2 days this has been for me. I'm kind of a boots on the ground as far as these presentations go. Come by this as a family law practitioner, and we're currently trying to establish a variety of programs to bring dispute resolution into our community. And one of the ways that, you know, when I was in law school in '87, there were no classes and no education on family law except in the realm of marital property. There was nothing regarding child custody or other family issues. And of course, that's developed into a very unique and complex area, and where dispute resolution is so needed. And in cases with children, the dilemma has been, as an attorney, to represent the client while also keeping in mind the best interest of the children. That's the standard. You can't ignore that, but sometimes your client isn't always on that path. And yet we require, even by law, that these parents continue their relationship even though they're in conflict. So what we're asking them to do is, in litigation, is to wage in a war and to engage in conflict, which we also know is the thing that damages children, is the conflict between their parents. And then saying, when the door hits you on the behind, go out there and co-parent and be successful at it and don't hurt your kids anymore. So as a lawyer, I had a real concern about being more a part of the problem than a part of the solution. And in fact, even got so burned out by it that I quit the profession for about 5 months to be a headhunter, and realized I wasn't pursuing the mission. So was able to survive and get back into the profession thanks to the dispute resolution process of collaborative law. Collaborative law taught me that attorneys are pretty uncomfortable as a rule with emotion. And collaborative law is a process where through a series of meetings, you have a communication facilitator who is a mental health professional to control the emotion and the communications, and the attorneys represent the clients. And what I learned from that process is that having the assistance of other experts in the room, such as those mental health providers, really made me more effective as a family lawyer for my clients. And so now collaborative law, though, is not particularly accessible to the general population, especially those in lower and middle income areas. And so my concern was, how do we merge that kind of talent and expertise, get the lawyers on board, and make a process that's accessible to everyone, and affordable to everyone. And so because family law is, I'm always going to be able to make a living, and so are family lawyers. We're always going to have that work to do. So I will tell you that my first collaborative law case, my client broke down into tears, and her husband stiffened up thinking, oh, sure, this isn't going to go any further. And the two lawyers ducked our heads and thought, well, this is over. I mean, what are you going to do? She's in tears. She's not capable of moving on. And that mental health provider communication facilitator came in, said, hey, do we need to take a break? Acknowledged her feelings, and said, this is difficult. What do we need to do? Whatever they do, but the lawyers weren't capable. And my client absolutely felt acknowledged, was able to move on with the process. Both lawyers popped their heads up, and so did the husband, and the magic worked. And we were able to move on and settle that case eventually. So how do we bring that magic to the general populace has been my project to figure that out. And because what I learned from the mental health professionals is I'm not going to be able, as the attorney representative, I'm not going to be able to fully advocate for my client if I don't consider those communication, education, and mental health aspects of the case. If I can't handle that, I need to figure out a way to make that happen. So what we're trying to do, I also, after practicing for 22 years, was able to be the director of the programs for our social workers who conducted custody evaluations. And what I found, because I'd already known that these folks had such powerful skills, I had all of them trained in mediation and dispute resolution processes, so that when they were working with these parents, that they could find the openings, get them communicating, figure out ways to bring them together and avoid the litigation, because litigation is conflict and conflict hurts kids. So and they of course embraced that concept. Now that I have the opportunity with our volunteers to handled family law mediations for lower and middle income folks. How can we incorporate these concepts? And so what we've tried to do is first do a preparation prior to mediation in which the parents are educated in basic communication tactics. And the people we're using to do that are the mental health providers, these social workers. So I had the great opportunity to collaborate with them. And what they would do is they talk with both of these parents, work with them on educating them about communication styles, communication skills, the necessity for their child to work towards co-parenting and at least staying out of conflict. And what I'm finding is that these parents are very receptive to that. As an attorney, I don't think I was more directive. Social workers and these mental health professionals know how to bring this out in folks, know how to educate them in ways that they can hear. And then once they've educated them, then they move on to keeping them focused on macro goals. And those macro goals are, what do you want? What do you want for your child? What are your goals for your child? And what do you think the other parent's goals, so that we get the empathy going? Again, they're talking these things over with this mental health provider as part of a preparation for mediation. And what we found in having them focus on those macro goals is that every one of them, I can't think of one mediation that we ended up doing where we didn't start where their macro goals were aligned, because they did want the best thing for their kids. They do want to do the right thing by their children. And having these folks prep them in a way that in a safe environment that's calming, allowed them to set these macro goals and then to come into the mediation more prepared to actually move forward and think about the other person's perspective, and then basically teaching them dispute resolution skills, because that's what they're going to have to use with each other for the rest of their lives. And as we all know, it applies everywhere in life. So what we found, and again, this is anecdotal a little bit, because we have probably used this process in about 50 cases, but we have been almost 100% successful in resolving custody disputes through mediation by using this preparatory process. Not only that, but we have found that we have not exceeded 5 hours, which honestly, collaborative law taught me people really don't hold up well after a couple of hours. However, there's ways to monitor that and make it better. But that's an expensive process in both time and money to have a series of meetings. And so, and also the lawyers are and the judges are very used to the concept of mediation being a one-stop shop. So we had to kind of honor that. And so this prep helped us to honor that, because we were able to keep these short. These weren't marathon mediations. And we were able to watch these parents come to their own, to self-determine, which we know is better for buy-in. It's going to be better for their relationship that does have to continue in the future. And it was just, again, very gratifying. As Nancy Welsh says in her paper, we saw the magic. And so our project is to try to incorporate some of that prep. Certainly, we would love to have mental health providers involved in the mediations as well. But again, that's an expense thing in both time and funding. But the preparation part, we have some resources to be able to get them to help us on that. And we found that when they come in, even if we don't have the actual mental health provider there in the mediation, we're still cutting those mediation processes in time. So we're also giving them so many added tools for their co-parenting toolbox, which is also a huge mission of dispute resolution, because again, litigation's conflict, and conflict's bad for kids. So that is where we're headed. And I don't know, what's my time?
5 minutes.
5 minutes, okay. We have also found that the lawyers are more amenable to being able to have that process to themselves. Incorporating somebody non-legal into the mediations has been a concern of the lawyers. Now, that's a cultural change. I'm working on it because I do think collaboration in family law is necessary and provides much better service for our clients and our community in general. And my hope is that there will be more collaboration and more acceptance as we move on. And as Carrie has shown us, it takes time to influence and make change. But I think we can do it this way and start leading the way in bringing parents out of conflict when they're dealing with a family law case.
So I think we've got, what, 3 minutes for questions?
3.5.
3.5 minutes, so for questions, comments. And I don't know, we haven't really given anyone on the Zoom a chance to comment. So if you want to raise your hand electronically, if there's someone who wanted to say anything or give a suggestion to Janet. And of course, remember, we've also got the link, so you can always send things.
Yeah. And Sherry made a comment that she didn't think conflict was bad, but that conflict handled poorly is bad. And that's definitely true with regard to parents and children. And so you're absolutely right. Conflict between the parents does harm the children, but if we can teach them, give them skills and tools to manage that conflict, then you're right. We're not going to get them out of conflict. And let's give them the tools.
Right, so I think we're probably, I've seen hands flying up, so I think we're probably at the time. So we'll move on to our next presenter. Thank you, Janet. Please, folks,
Thanks.
give your comment.
Thanks.
Thank you very much, Janet. So now we are moving to Angela Downs, who is a professor at UNT Dallas College of Law in Dallas, Texas, where she is Assistant Director of Experiential Education. She teaches clinical courses, the 40-hour mediation course, as well as domestic violence and the law, an innovative approach to interpersonal violence. She's also an associate municipal judge for the city of Glen Heights and Irving, Texas. Welcome.
Thank you so much. And I am actually going to share my screen as we get started. Let's see. Okay. So I do want to thank Texas A&M University School of Law and the organizers of this event, Peter and team, for doing such an outstanding job of bringing all of these wonderful folks together to share their works and really creating a platform so that we can talk about things that we're working on. So one thing I do want to share with everyone, front page of the Dallas Morning News this morning, there's an article. If you have not heard, UNT Dallas College of Law was granted full accreditation from the American Bar Association last week. We are very, very proud of this. And I do want to take a moment to thank Texas A&M for all of their support as we have been on this long and painful journey, but it's certainly exciting to be on the other side. So I'm going to be talking to you in my time about the importance of storytelling, civil discourse for mediations and ADR practitioners. And as we were thinking about this, this is a project that I'm working on with Professor Kay Elliott, who is legendary in the field of mediation. We've been working and thinking about what it is that practitioners need. So why this book? We've been thinking about the issue of lawyers as storytellers and mediation specialists and practitioners as storytellers. We know that humans tell stories. In the context of thinking about this work, we also want to explore what it is that the 21st century practitioner needs. We've also are examining social tensions. There's a lot of different things that have been bubbling up on a variety of levels here recently that we think that mediation practitioners need to be ready for, but they also need the tools in order to navigate some of these landmines. And so one of the things that we have been looking at as we've done this exploration is the issue of civil discourse. We think that this might be a very effective tool for mediators to put into their arsenal of things that they use. I was very excited to hear Janet talk about collaborative law as a tool. Collaborative law has been revolutionary in how not only in the practice of law and how we've looked to non-traditional areas of coalition building and problem resolution, but it's really changed how lawyers, mediators look at issues of family law. And so we think that civil discourse might be another method that could be revolutionary and to really move the needle on what mediators are bringing to the table. Storytelling, we think, is something, if we look through the lens of diversity, equity, and inclusion, storytelling is a very effective tool in the area of diversity, equity, and inclusion. And what we really are focused on looking at through that lens is how you can use storytelling as a tool to really move the needle in your mediation cases. So we all know that humans are storytellers. This is a cave painting from the Chauvet cave in France. It's a very famous pictograph that shows that even centuries ago, we were telling stories. So we know that storytelling is something that is woven into the fabric of who we are as humans. And we know that everything that we do as practitioners is really telling stories. As mediators, you're there to help and facilitate conversations and helping the sides that are being brought together for a conflict tell those stories. So what can we do? What does that mean? So we looked at storytelling really around the world. If we look at, kind of moving from that one of the first documented examples of storytelling in the Chauvet case to looking at storytelling around the world. And one of the things that we know is that every culture has some method of storytelling. You know, if you look at the hula in Hawaii, Chinese shadow puppetry, the Zijal in Lebanon in the Middle East, Kunto in the Sicilian culture, and Rakugo in Japan, the griot in West Africa, and then even in our Indian traditions. So we know that this is really baked in to the fabric of who we are as humans. And if we look at our second tenet that we're going to be focusing on, the 21st century practitioner. Now, one of the things, and I feel like this is kind of top of mind for me, having just gone through this accreditation process at the law school, are the changes to the bar exam. We know that the traditional methods that, for those of us that went through law school during a certain time with the Socratic method, there's been a re-examination of some of those skills. And there is a shift in order to broaden the spectrum of tools that the next generation of lawyers have. This includes ensuring that students really have a practical sense of what it means to practice law. So that's really tying the analytical skills that you get in the course of a law school course of study with practical skills. And the ABA has been very clear about that. And so I think in thinking about that, we've got to think about what it is that we need to integrate as mediators in order to be effective. So looking at issues of collaboration, looking at issues of empathy, sympathy, and some of the other tools that are out there, intellectual, emotional intelligence and intellectual examination. And then with the 21st century practitioner, I think if anything, COVID has really brought to the forefront that we have been able, the shift in flexibility that we have to have. I think if someone had told us 2 years ago that we would be meeting in a hybrid format for the majority of conferences and meetings, we would probably say that they were crazy. But now we're doing it effectively, but we've got to think about that because that shift has not only been challenging on some fronts, but it's been effective in some fronts. We're finding with Zoom mediations that parties, particularly if it's a pro bono setting, are more inclined to work because they're in a comfortable setting. We've got to also figure out how are we going to deal with mental health issues that have really come to the forefront as we are dealing with the aftermath of COVID and the variants that have come down the pike. Also, we need to think in terms of the 21st century practitioner, changing demographics. We know that the demographics of our country is changing. We know that there are estimates with our last census that those of Hispanic descent will possibly become the majority of our country as far demographically, and also folks that designate themselves as mixed race. So we've got to be ready for those things. And that's a call for us that we're going to be talking about in a minute to really do that self-examination piece. I bring this up as we are talking about kind of what our 21st century and next generation lawyers are facing. This is a page from Black at Harvard Law, and it's an Instagram account that students in Harvard put together, really talking about some of the transgressions and some of the things that they have found, the microaggressions, and some of the other things that they have seen with respect to who is serving to teach them. There were notations that all of their professors were white. They didn't have any professors of color in that first year, and just some of the other things. So we know that those that are going into the profession and becoming our mediators of the future are facing these issues, and we've got to be ready to deal with it. And we've really got to take a good hard look at what we're doing to ensure that there's inclusivity, diversity, equity, inclusion in the process that we are setting forth. Also, the issue of social tensions. We know that there has been a lot of strife. There's been a rise in police brutality cases with George Floyd, Breonna Taylor, Ahmaud Arbery, and others. There was a rise in Asian hate crimes. We know that President Biden has looked to actually sign law to really target Asian hate crimes. There's been a rise in anti-Semitism. Even most recently there was the hostage situation at the temple in Colleyville, issues of critical race theory and book banning, and most recently this week with the Supreme Court nominee, Justice Ketanji Brown Jackson, with calls for her LSAT scores to be released, transgender and LGBTQIA. So there are things that are happening in our society, and all of these things actually bleed into what we are doing in our work as mediators. These issues affect our work. And so we've really got to think very seriously about what it is that we are putting out, what are the tools that we have, and how we can, of course, be more inclusive. So I'm going to take just a moment of personal privilege related to the Judge Ketanji Brown Jackson nomination for Supreme Court. She is the first African-American woman to be nominated for this role. And my law students have created a campaign called Pass the Gavel, where it's a letter writing campaign where you can write letters or templates that they have created, and a way for you to go to the website and actually cut and paste letters to send to your members of the Senate Judiciary, as well as your senators in your state. So just a shameless plug for our civic duty on that. So let's get to civil discourse. It's defined as a conversation or discussions where there is a mutual airing of often opposing views without rancor, but with the intention of promoting greater understanding while moving toward solutions. And we think that this is a very important tool that we really need to embrace as mediators, really examining civil discourse as a method to move the needle, because part of what we're doing as mediators is we're seeing people at their absolute worst. We are seeing them where we are brought in to facilitate. And so the tenets that are embodied in civil discourse, we believe, can really be one that you can include in order to provide the tools that we need. So moving quickly to storytelling, we know that storytelling links the head, the heart, and the mind. If you think about some of cases, if we think about things that have happened, lawyers and mediators are storytellers. This integration is really the key to the development of intercultural competence. There's a lot of science that's emerging that find that stories help us better understand others' intentions and relate to one another better. One of the things that we talk about is you have got to develop empathy. You've got to be able to walk a mile in someone else's shoes. That definitely makes you a better mediator. But really getting outside yourself, doing that self examination to really understand where is it that you're coming from. What are the things that you need to work on as a mediator, I think is really key. But really understanding the stories of others, reading about folks who are different from you, really getting to know people that are different from you can make such a difference in your practice. And this isn't to say that you can, say that, just because I have worked with someone of a certain cultural background that I understand that entire culture. But what it does is it broadens your perspective and it lends you to ask the intelligent, the relevant questions in order to be a better mediator. So that's what we're really going to be focused on. There was a wonderful 2010 study on the power of neural coupling and the power of storytelling. We know that our brains have receptors. The brain science is very clear. This study actually measured how the brain reacts if there's a storyteller and there's a person that's receiving or listening to the story. At some point, what happens, there's a mind meld where the person that's the receiver of the story actually starts to feel the same emotions, understand, which is why sometimes when you are in the room with someone and they're telling you a very sad story, you start feeling those emotions. You've got those mirror neurons in your brain that are triggering, that are firing off and are really making you feel the emotions that are going through with the other person. So we know that the science is clear. And so the tool that we're going to be talking about, among some other things, is really cultural humility. Cultural humility is the act, it's a lifelong process, and what it is, it ensures that you learn about other cultures and are sensitive to cultural differences. I think if we talk about all of the things that are happening with our changing demographics, with the things that the ABA is really highlighting as what practitioners for the 21st century are going to need, cultural humility is really one of the keys to ensuring that you're ready for that. It's a lifelong commitment. So it's not something that you take a class and that you are done, but what it is, it's a lifelong commitment to self-examination and self-critique. So you are constantly asking yourself, how am I reacting in these different situations? How did I react in this situation? Was it good? Was it bad? What can I do? How can I make it better? You've got to have a desire to fix power imbalances. So you've really got to be dedicated to ensuring that we create an even playing field for all participants and everyone. And one of the things that's key about this is you're not doing this work in a vacuum. You are actually developing partnerships with people and groups who advocate for others. So that, along with some other things that we're going to be talking about, intellectual humility, sociological perspectives, and then really the effect of cancel culture. I mean, I could talk about cancel culture probably for the rest of of the day, but really getting to a place where we're not just canceling, but we are really taking the opportunity to explore differences and really looking at how we interact with our roles as lawyers, advocates, mediators, influencers, citizens, and potential peacemakers. So that is what Professor Kate Elliott and I are working on. We are very, very excited about the exploration that we are undertaking, and we really hope to have meaningful work that can be shared with practitioners and can really change the landscape of what we do. So I'm going to put my contact information, and I actually took a little screen grab of the Dallas Morning News this morning. That's my contact information, and I think I have probably about 5 minutes or so for questions.
Actually, your time is up. So there's
Okay.
no time for questions. But people can send you comments. They've got your email address here, and then we also have the link so people can send comments to you via the link. And we'll be, as I've said before, putting all those comments together and sending it out to each of the speakers, the comments to them. So please share your thoughts with Angela via that link, and we're going to move on to our next presenter.
Okay, actually, we've got two law school students who are going to be presenting. The first is Mark Gannon, a second-year law student here at Texas A&M. and an incoming citation editor for the Law Review. Importantly, Mark's position as the middle child in a family of 5 kids often puts him in the position of mediator for family drama.
Very true. Thank you, Professor. And howdy. Oh, sorry. Always wanted to do that. Wow, it really feels kind of surreal to be up on the same proverbial stage as so many distinguished panelists and presenters that we've had this weekend. I think I'm not alone. I think my colleague Emily Earnshaw will agree that we are very excited to share some of the work that we've been doing with the Law Review the past few months. For me, Professor Riley didn't mention this, but I'm the son of 2 doctors. I'm from a medical family. So it's kind of my thing to talk about healthcare at length, much to the chagrin of my friends. But as I'm sure everyone in the room and on Zoom is aware, the cost of healthcare in the United States is ridiculous. In fact, the #1 cause of personal bankruptcy in America is medical debt. Well, I have good news for you. Congress is aware of this issue, and they're already passing legislation to address it. For instance, the No Surprises Act, which went into effect in January of this year, bans balance billing or surprise billing. This occurs when a patient sees a doctor that they think is in network with their insurance company, but surprise, the doctor's out of network. Sure, the insurance company will pay a little bit of the bill, but the doctor thinks, I'm owed a lot more for my services, so they send the rest of the bill to the patient. That's how you get those crazy, insane medical bills that you see on social media. Well, the good news is that's not allowed anymore. The patient pays their copay and then they're held harmless. They go their separate way and don't have to worry about it anymore. Additionally, the Act created a dispute resolution system so that the insurance company and the doctor can hash out how much the doctor is going to get paid for the service. Sounds simple, right? Easy. Great for everyone involved. Wrong. The dispute resolution system doesn't work. Well, functionally it works. It's in-person baseball-style arbitration. Baseball-style meaning both parties submit a proposal for payment to the arbitrator, and based on a list of factors that are spelled out in the Act, the arbitrator either says, party A, you win, or party B, you win. Oh, and because you lost, you have to pay my fee. And did I mention that both parties, you also have to pay fees to government organizations that maintain the system? When you add in attorney's fees and travel costs, because I'll note, this is a federal act. Someone's getting a plane ticket to get to the venue to resolve the dispute. That's a really high barrier of entry for a dispute about compensation. I'll also note that this happens surprisingly often. This is a routine dispute. So we have a time-consuming, costly system to resolve a routine economic dispute. It doesn't really seem like it's serving the needs of the parties here. And as we've learned from our wonderful panelists this weekend, the needs of the parties are key to effectively resolving a dispute. So what do we do about it? Well, I've already set out what kind of dispute we're dealing with. So what are the parties' needs? Assuming that they're both acting in good faith, and I'll let you make up your own mind about whether the insurance company actually wants a functioning system. The parties want a system that is time efficient, low cost, with as little hoops to jump through as possible. We can solve that. And if you've read any of Colin Rule's work, you know where I'm going for the first step. Online dispute resolution. If we want to eliminate travel costs and we don't want to rent a venue, why not just hold the proceeding over Zoom? It's easy, but we can go even farther. Hold the whole thing over email. The arbitrator already has all the information that he or she needs from the complaint. And if something gets left out, just shoot an email to the party and say, hey, I need X, Y, and Z with documentation, please. That certainly cuts down on time invested. It's a lot more flexible. And for the doctor, at least, less time invested and more flexible means more services rendered. That's more money made. And if you care about it, more patients treated and happy. But we still have an issue about cost with that. And that's where my research starts urging something that sounds radical, but actually isn't. Automated dispute resolution. Now, you might try to stop me here and say, Mark, let's be realistic. I didn't sign up for a sci-fi presentation today. But these kind of systems already exist and are solving problems today for the exact kind of disputes that I'm talking about. Whether it's simple things like e-commerce or parking tickets, to even things like landlord-tenant disputes, automated systems are already solving problems and serving as neutrals today. Then you pretty much eliminate the problem of cost. You don't have to pay an arbitrator there. You can eliminate flat fees for the government by implementing a take rate, which I talk more in depth in my comment, and will actually make a greater profit for the government in the long term if they care about that. You also likely don't have to even worry about attorneys, even though these are big companies and they have in-house counsel. They don't have to contract it out for a lengthy dispute. So this is a time-efficient, low-cost system, very little hoops to jump through. So why isn't it already implemented? Well, the reality is, as I'm sure you're all aware, the government is both lazy and bad at technology. So these sort of systems, while I'm very happy that they're starting to implement ADR into the law as opposed to litigation, they're not going far enough in developing systems that actually serve party needs. Well, now we get to the so what, the and that Professor Menkel-Meadow urges us to consider with these kind of issues. Why should you care if the system stays broken? Well, if the system stays as is, it'll raise the cost of healthcare for everyone listening to this right now. What happens if the system is broken? Evidence is already indicating that doctors, billing companies are just saying right off the bat, it's too expensive, too many hoops to jump through. Just don't bother with it. But that doesn't mean that the doctors are absorbing the losses. They're professionals. They still want to get paid. So what they do is they turn around and they raise their rates for in-network services with the insurance company. And the insurance company isn't going to give up their profits either. So they turn around and they raise premiums for all of you, for every consumer, for every patient. So an act that was designed to reduce the cost of healthcare is actually going to raise it because Congress did not address the needs of the party in designing the dispute resolution system. Thank you.
Time for
Got about 2.5 minutes.
2.5 minutes.
Yeah.
Please, I would love to hear that.
Fabulous.
Speak it like.
I'm going to talk very fast because I know we need time, but that's fabulous. It's a fabulous paper. I just have two quick comments. One is on the arbitration thing. Nobody mentioned yesterday something I participated in years ago. ICANN, the designated names on the computer. It was a totally online arbitration system. So ICANN, look it up.
Okay.
I don't know if your comment's already done or not. There's a model for that. But more importantly, I alluded to this yesterday. In 1993, when I was in Washington, I did a little consulting for Hillary Clinton's proposal to do single payer healthcare. And one of the issues was, it's the best moment in my life. I had to take everything I knew about ADR and get it in healthcare and get it into a 3-page memo that went to her commission. And then I testified and talked to the commission, not to Congress, about what should go into a single payer healthcare plan to use ADR to reduce costs. And I don't know who's listening to this, but I talked to her, and then I got involved with the Justice Department, and then on the Hill, same issue. It got killed. You know who killed the ADR in healthcare?
Love to hear it.
Well, the public story at the time, of course, after the whole thing failed, was the insurance industry, who had all the reasons that you're talking about to benefit. But actually, it was the plaintiffs' lawyers.
Really?
The plaintiffs' lawyers that were afraid, and we already have this in a lot of states. Wisconsin's been doing it for years. The plaintiffs' lawyers were afraid of medical malpractice ADR. And the doctors wanted it, of course. My brother's a doctor, so I'm a physician, so I know they wanted it. Lots of issues about, who then gets, in the public registry for having a malpractice claim, but clearly reducing the cost was very important to them, and having confidential private ways to resolve, to actually sometimes apologize for medical malpractice. But I don't know if anyone knows that, and I don't know if you can dig this up anywhere, because I think it was not covered anywhere. I was shocked because a lot of those plaintiffs' lawyers, I'm not revealing anything people don't know here, were Democrats. And so the plaintiffs' lawyers from Texas, I spent a lot of time with some of the big plaintiffs' lawyers here in Texas. that were doing asbestosis cases and all of that stuff. So greatly progressive people on a lot of issues, funding the Clinton election campaign and lots of Democratic causes, and they were responsible. I was told, thank you very much at the end of this. Thank you very much, Professor Menkel-Meadow. This is all very interesting. And I learned later that it was the plaintiffs' lawyers that got it out of the bill, out of all the proposals, and that was the end of that. So this is great work, Mark, and I hope everybody listens to you.
We've got the link that you can get in the chat to send comments, so please send Mark your comments, and we turn it over to Emily.
Right. Emily Earnshaw is a second-year student here at Texas A&M School of Law. She's an incoming managing editor at the Law Review. She is a former high school English teacher and became interested in her current research into family law arbitration in Texas, in part through her experiences helping her students.
Yes, no, thank you for the opportunity to come and just present, maybe not as articulate as ideas as Mark, because I realized when I picked my topic, it was a little bit of a bigger, I bit off a little bit more, I think, than I could chew for the purposes of a comment. And so also, in addition to helping students in the classroom and seeing the effect of not arbitration in family law, but the effect of messy divorces and bringing those behavioral issues, emotional issues into the classroom. I also had the opportunity to work with a local pro bono family law firm last summer, and we dealt exclusively with low-income clients who either had some sort of domestic violence issue in the relationship or child abuse as well. And so that's kind of the lens that I focused when I was thinking about my research. And Professor Welch was my faculty advisor, and so I was spitballing some ideas of, okay, well, how can I take what I'm interested in and kind of turn this into a comment? And she's like, well, have you ever heard of the Uniform Family Law Arbitration Act? And I said, people arbitrate family law disputes. Taking the ADR survey class, you know, I had a basic understanding of arbitration. It's contract driven, it's sophisticated parties, or at least it's intended to be, and it's completely out of the court. Arbitrator makes all the decisions. You just turn in your award to the judge at the end, and the award is pretty much enforced. And so thinking from my lens of, well, who would arbitrate these family law disputes? I was like, well, does Texas do this? And so I was like, yep, sure enough, Texas actually does. Texas has been a leader in ADR for a long time. And we actually passed our, our bare bones legislation. We've got a little bit of arbitration carve out in both divorces and also child custody disputes. But it's very minimal. And so kind of what drove my research was looking at the Uniform Family Law Act and putting up what Texas already does in existing case law with the statutes, and just think about, what is Texas doing well? Why is it doing it that way, just through reading the case law? But then also some ideas for how Texas could improve its, family law arbitration moving into the future. And so I think for me, it was good to think about questions. So first I started with, what is the UFLA? And that's where I started my research. Does Texas arbitrate? Yes. And then I was like, well, should Texas adopt the Uniform Family Law Arbitration Act? The answer is no. Texas has not adopted either the UAA or the RUAA. We actually have our own. It's the Texas Arbitration Act, which was itself significantly revised in the 90s as well. And so adopting the Uniform Family Law Arbitration Act, it doesn't fit for Texas. And then I went to, like I said, comparing how Texas does family law arbitration to how it's proposed in this uniform law. And what I found was that Texas family law arbitration is what I call it's almost a kissing cousin of the UFLAA. Although the legislation is very bare bones, we as courts in Texas, we automatically integrate the binding arbitration of the Texas Arbitration Act into interpreting these decisions. So having done all of that, some things that maybe Texas could improve upon is providing some greater protections for children in particular. What's I think fascinating about the Texas statute is it gives automatic, well, it should give automatically a reason for a court not to enforce an arbitral award that has child custody issues. Normally, courts should just enforce. They say a court shall enforce unless you bring this dispute before a non-jury hearing for the judge, and the judge determines whether they think it's in the best interest of the child. You would think that that would be an automatic thing. Texas courts have said it is not automatic, so you have to raise the issue before the judge before the award is enforced. And then what's also fascinating is, I think for me, my conflicting passion, I guess, and it was difficult for me to fathom this, is you can waive through your arbitration agreement the right to have this best interest hearing at the end of arbitration, which I think it conflicts in me because I understand parties wanting to fit the form to the fuss and having parties really determine, have the parents determine what's going to fit best for their lifestyles. But if you have elements of child abuse, if you have elements of domestic violence, you also have an obligation to protect the vulnerable parties, especially in binding arbitration. And so the fact that in Texas, you're able to waive this right to have your child's best interest heard before the court, I think that is something that Texas could change. Some other things that are proposed in the UFLIA that I think would be beneficial would be giving arbiters more power in the actual arbitration proceeding to stay proceedings, and if an issue of domestic violence arises, then you take it to the judge, and the judge determines is the arbitration going to go on, or it affirms with the party that they do want to go on, even though they've got these issues within their case. And then also making arbitrators mandatory reporters of issues of child abuse come up in the course of arbitration. They're going to automatically stop proceedings and make that mandatory report to CPS. So I think that those are things that Texas could take a look at. But being a student of Professor Welsh and also being a research assistant and helping her with some things last summer, it's always crucial to look at the data. So if you already have things in place and you don't really have a reason to change, then you need to have some data in order to maybe justify making that change. And so in looking at it, doesn't look like the UFLIA was based on any specific data connecting arbitration to these issues. Now we've got some more developed case law, but again, there's no data to suggest that these issues are coming up in arbitration. So that's something that I also put in my paper. So, okay, that was my spiel. Thank you for listening. It really has been a wonderful day, and yesterday as well. It made me, I think, sorry, I don't need to just talk, but it really was refreshing to get out of the classroom and listen to people who are passionate about their subjects. Not that we don't get that in the classroom, but people who are truly knowledgeable and passionate and have been lifelong learners in the field that they've chosen to study, share and dialogue with each other. So thank you for allowing us to do this, and thank you for letting students come into the process as well. This has been really, really exciting.
Wonderful.
Okay.
Is there any time left?
It's a little shy.
Okay, so if there's anyone who wants
Comments?
to give comment or question.
You two are ready to go to the other side of the podium.
I'm not ready to go back yet. I'm still enjoying being a student.
Already. I
Yeah.
understand, but
Thank you.
Wonderful. So if anyone has comments, we've got the link in the chat, so please send them to Emily and we'll make sure that she gets them. So thank you. Yeah, just, we've got one comment.
Okay.
Oh, I don't. It's not a question. It truly is just, hi, this is Meg. I know I've met most of you yesterday. You saw me pop in and off of the screen. I just wanted to say how proud I am of both of you. This is not easy to come up here as a student and talk about your note and comment you've been working on since July.
Yeah.
So, Mark, Emily, huge congratulations.
Thank you.
Thank you for enjoying this opportunity
Yes.
and taking advantage of it. I love it.
Yes.
Thank you so much.
Thank you.
Thank you both.
We'll move on to our final presenter.
Yes, our final presenter. And I'm glad that you made that comment about the conference. And, you know, I think Carrie has inspired all of us to be lifelong learners.
Yes.
So that's definitely a theme of the symposium today. So our last presenter is Hiro Aragaki, and he's professor of law at Loyola Law School in Los Angeles and a professional research associate at SOAS School of Law in London. His scholarship on arbitration has been published in top US law journals. He has recently focused his attention on ADR in the developing world, particularly Africa and Asia. And he is a fellow of the College of Commercial Arbitrators and in the United States and the Chartered Institute in the UK. Hiro.
Great, thanks, Peter, for that really nice introduction. Hi to everyone. Hi, Carrie. I'm so sorry I couldn't make it yesterday. I'm traveling right now, and I had a pre-existing conflict with yesterday's session. Can you all see the slide that I put up? I can hardly see you all, but is that a yes? Okay, great, perfect. So the title of my talk is Should Developing States Ratify the Singapore Convention on Mediation? And so my time is limited, so I'm going to try to breeze through all this material as quickly as I can. So I think most of us know that the Singapore Convention really is the mediation equivalent of the New York Convention on the Enforcement of Foreign Arbitral Awards. So I'm not going to go into much detail on the terms of the convention. Like the New York Convention, there is the Article 3 that essentially compels states to enforce the mediated settlement agreement unless one of the narrow grounds for refusing enforcement, in this case, Article 5, exist. And, you know, there's been a lot of commentary that the convention, I guess, came into force in 2019. And there's been a lot of practitioner, primarily, commentary and some scholarly commentary. A lot of it has been very enthusiastic about the convention. I think there are many things that are good about the convention. I guess my piece is a little bit more skeptical than what has been written so far, largely. And I'm also trying to carve a new path, really, by shedding a law and development perspective on the convention. So let me see if I can explain a little bit of the development angle here. So this map on the right and the chart on the left gives you a profile of the countries that have signed and ratified the Singapore Convention, now about 2 years after it went into force. So if you look at this table, this top row categorizes countries based on whether the IMF deems them to be advanced, emerging, or PRGT. So you can think of the advanced countries, these 5 countries here, as developed states and the rest as developing states. The countries shown in bold in the table are countries that have both signed and ratified the convention. The rest of them have only signed the convention. And as you can see, there are really only 9 ratifiers here. So it's too small a sample size to say anything meaningful about the convention. So in this paper, I focused instead on the much larger number of signatories, which is about 55, I think, at this stage. Now, you can say that focusing on signatories has limited value because a state doesn't assume any obligations under a convention just by signing. It's only by ratifying that they do so. But I think signing can be taken as an expression of interest in the convention and perhaps an indication of whether a state will ratify in the future. And that's all I'm really using it for at the moment. Now, I think what's really obvious as you look at this table is that it's overwhelmingly developing states that have signed the convention. This wouldn't be surprising given that developing states outnumber developed states by about a factor of 4 or 5 to 1 in the world. But in the paper, which I didn't share with you, but I'm happy to circulate if people want a copy, I controlled for this, and I still found that developing states are signing on to the convention at a rate of more than twice that of of developed states. And this is really the opposite of what you would expect, right? Developed states tend to have more mediation activity. They have more to gain from an international enforcement regime. So the question really that I started out with is, why are developing states expressing such interest in this convention? And I think the two kind of traditional explanations that pop to mind are, one, maybe they're interested in solving an enforcement problem, a problem with the enforceability of mediated settlement agreements. I think this is a less convincing explanation. There really is very little empirical evidence of an actual or even a perceived problem with enforcement, certainly not enough to justify an international convention. So this doesn't strike me as a particularly persuasive reason. I think maybe a more promising reason why developing states might be interested in the convention is that they see it as a way of promoting mediation, right? So that might be the case domestically. That's the first bullet here. So a lot of states, developing states in particular, have huge court backlog issues, and they see mediation as a way of alleviating some of that backlog and increasing access to justice. The problem is that the convention doesn't really speak to domestic mediation. It doesn't have any applicability really to the domestic sphere. So states that are looking to the convention as a way of improving more uptake domestically, I don't think they're going to get that out of the convention. Now, the second two bullets here really focus on the cross-border context. So it may be that developing states want to promote more cross-border mediation. So for example, by encouraging their citizens to make more use of mediation in cross-border disputes, or maybe it's that they want to position themselves as regional dispute resolution hubs to attract mediation business from internationally. I think the problem here is that the convention is unlikely to help in either of these ways because of something that I call non-reciprocity. So this is a feature of the convention that I don't think is really well understood, and I'm going to try and see if I can explain it here with this map. So all the grayed out countries here, like the US, have not ratified the convention. So they're not contracting states of the convention yet. The green ones, Honduras and Ecuador here are. So let's take an example of a US party and a Honduran party. They enter into a business transaction involving commercial real estate throughout the United States. A dispute arises. They decide to mediate at JAMS in Miami. And they eventually reach a settlement, and they execute a mediated settlement agreement. So later, as often happens, a disagreement arises about the terms of the settlement agreement. Let's assume now that the US party wants to enforce the settlement agreement in Honduras. So this is this slide, trying to enforce this agreement in Honduras. And the question is, can the US party do that under the Singapore Convention, even though the US is grayed out here? It's not a ratifying party, it's not a contracting party to the convention. And the answer, surprisingly, is yes, because what the convention does is it obligates states like Honduras that contract to the convention to essentially open their doors to mediated settlement agreements from anywhere in the world. And so I think this has at least two implications. First, countries like the US don't really have to ratify the convention at all in order for their nationals to make use of the convention in countries like Honduras. And so that gives countries like the US very little incentive to ultimately ratify. And second, by ratifying the convention, really all Honduras has done is to make it easier for parties from outside of Honduras to enforce MSAs against assets located in Honduras. So if you look at this table on the left, I'm going to put a check mark here. The MSA would be enforceable in Honduras, even though the US is not yet a contracting party. So let's take the opposite example here, where we're trying to enforce in the US instead. If the Honduran party now wanted to enforce the mediated settlement agreement in the US, could they do so? And the answer here is no. And the reason why is that the US is not a contracting party yet. So the US would have to do that first in order for the Honduran party to be able to enforce the mediated settlement agreement there. So the upshot is that I think it's hard to see how by ratifying the convention, Honduras incentivizes its nationals to use cross-border mediation more, because in this example, those parties would still not be able to enforce the mediated settlement agreement in the United States. It also doesn't make it any easier for mediation institutions located in Tegucigalpa here to attract more regional mediation business. Why? Because Honduras's ratification alone doesn't give users any more confidence that if they use a mediation institution located here in Honduras, that the mediated settlement agreement will be more freely exportable in jurisdictions like the United States. All Honduras's ratification accomplishes is to, one, make it easier for the US party to enforce the MSA against assets located in Honduras, and two, for MSAs reached at institutions like JAMS in Miami to be more freely exportable throughout the world. And I guess the problem that I'm concerned about, right, is that if many more developing states end up ratifying the convention, like Honduras, I don't know if you can see my my pointer here, but if many more developing states end up ratifying, which seems to be the case given what we're seeing with the countries that are signing so far, it could very well become a north-south issue, maybe akin to what we've seen in the ISDS context, right? So MSAs will become much more enforceable. Where's my cursor? Much more enforceable in developing states and almost unenforceable in most developed states who so far seem to be sitting out the convention. And I think that'll be a problem, not just optically, but because I think it will really put developing states kind of in the service of businesses and other parties in developed states who will more easily be able to enforce mediated settlements against assets located in those states. Of course, that hasn't happened yet, only 9 ratifiers so far. And I'm not trying to argue that it will happen. Quite the contrary, my argument hopefully is that, that it shouldn't happen and that developing states should perhaps take a break and not sign and ratify the convention so quickly. So let me see if I can cover some alternative explanations if enforcement and promoting mediation are not persuasive explanations. Why else might developing states be interested in this convention? So the first one is expressivism. So developing states might view signing or ratifying as a way of sending certain signals. For example, that they're rule of law friendly, that they're pro-business, etc. And they may also be hoping that these signals will translate into certain collateral benefits, some of which may or may not have anything to do with mediation. So for example, when signing the convention, Jamaica's Minister of Justice remarked that, and I quote, "It is expected that Jamaica's signing will improve investor confidence in Jamaica and assist in improving our rankings in the World Bank's ease of doing business assessment." I know for a fact that India has also signed and will ratify probably the convention for exactly the same reason. I recently did a webinar on mediation in Nairobi, and all of the African mediators on the panel were insistent that their countries must ratify the convention immediately in order to attract more trade and investment. Notably, they didn't say anything about promoting mediation. Expressivism, I think, poses a risk, several risks. One is that developing states may not get the kind of trade and investment that they're hoping to get through expressive ratification of the convention. But I think we should also be worried about something known as decoupling, right? So this is an idea that if states are simply ratifying to express certain messages or send certain signals or get certain collateral benefits, they may lose interest once they get the expressive benefit they are seeking, or they may fail to follow through with their obligations, especially where monitoring and enforcement may be difficult. And I think that this might be the case in the convention situation because it's so new, and there's a lot of disagreement about what some of the provisions of the convention actually mean. The second explanation that I offer is something known as acculturation. So the idea here is that developing states might not be making an independent or merits-based determination about ratifying the convention. Instead, there may be acculturated into ratifying because they think it's the right or the legitimate or maybe the optimal thing to do. So you can think of this as the kind of the behavioral explanation or non-rational explanation for states' behavior, but just at the state rather than the individual level. Acculturation has roots in the long-standing research in institutional theory, particularly the work of Paul DiMaggio and his colleagues. And what they hypothesized and what they found was that organizations in a given market or region, they tend to outwardly conform to one another, even in situations where it wouldn't make sense for them to do so. And they call this this phenomenon isomorphism, and they hypothesize that it's especially likely to occur where organizations lack information, right, or expertise, and so may just be copying what other competitors are doing, or they may be prone to accept what professionals or other elites are telling them is the right thing to do. And I think that something similar might be going on here with the convention, in large part because the more traditional explanations don't seem to add up. But like expressivism, acculturation also raises a concern about decoupling. And the reason is that in acculturation, the acculturating party conforms not necessarily because they agree with the position. So in this case, the Singapore Convention, but simply for the sake of conforming. And I think that this might be particularly likely for developing states because the practical realities on the ground in terms of mediation, mediation law, the extent of mediation practice is just very different. And it might be very difficult for them to improve their context to significantly comply with what the convention will require of them. Really, my main recommendation for developing states is the second bullet. I don't think there's a need to rush and become a contracting state of the Singapore Convention. I think that developing states should rather take a wait and see approach. The best way to protect against non-reciprocity is to let developed states ratify the convention first. Let them build out the convention infrastructure. Because of non-reciprocity, developing states can still take advantage of that enforcement regime. They don't have to be contracting states to do so. And they can really make a better assessment given the success or maybe even failure of the convention as to whether it's in their best interests to ultimately ratify and become a contracting party. So that, in a nutshell, is this very early work in progress, and I'd be very interested to know your thoughts.
Thank you, Hiro. Does anyone have questions, comments in the room? Carrie does. So if you want to come to the podium.
Yeah. Hi, Hiro. Great paper. I think I sent you an email. It's Carrie. Try to send it to me. Obviously, you know this. I agree with everything in your paper, and obviously the thing to look at is the claims always that international investment arbitration was going to improve or increase investment in developing countries. And we know that's been a very mixed bag. It actually hasn't been quite as bad as my former colleague who, in London, who you might know about, Sona Raja at National University of Singapore, who's been a long critic of international investment arbitration. And we know from some of the empirical work that's been done that it's a mixed bag. So, but it's both that the claims that having this transnational form of dispute resolution was going to bring more investment has not been proven necessarily to be true. And the same on the other hand, it's been pretty clear now from some of the more recent empirical work that the developed nations are not necessarily winning in international investment arbitration as much as they thought they were going to.
Yeah.
So I know you know all of that, but it just struck me as you were talking about isomorphism that one of the interesting questions under the Singapore Mediation Convention is it going to look like in any way either the Washington Convention for International Investment Arbitration, or is it going to look like the New York Convention for International Commercial Arbitration? Those are two different, slightly different treaty systems. And so, I would just add in the paper, is the Singapore Mediation Convention going to be its own thing, or is it going to look more or less like either of those other two? So from a transnational dispute resolution perspective, terrific paper. I look forward to
Thank you.
reading it, and it's really nice to see you.
Thank you. Likewise.
I think Lisa maybe had a comment or question.
Yeah, this is, I'm out of my depth here, but my question, thinking about Mariana Hernandez Crespo Gonsted's work in Central and South America is one way around it for the developing countries to require the Singapore Convention to be incorporated into an international investment treaty that has an arbitration clause, in order to take care of the problem of asymmetric enforcement?
Yeah, I really don't know how you get over that problem, because the asymmetry has to do with a kind of foundational aspect of the convention. There's no concept of a seat of mediation as there would be in the New York Convention. I don't know how you implement a multilateral convention into a bilateral investment treaty, if that's what you are asking about. So I haven't really thought that far, but I will certainly think about it. This paper really has become a multi-headed hydra in some ways. I'd like to really kind of bring to the fore the developing state dynamic that I think is emerging, but this whole asymmetry / non-reciprocity issue is its whole other kind of paper almost, right? And there are lots of multilateral treaties out there that are asymmetric, right? So a lot of the common good or public good type treaties over the environment or common fisheries, for example, you can't exclude non-ratifying states from benefiting from them, right? Because you can't kind of stop the benefits of emissions from traveling across borders. And I think we're seeing a similar dynamic here. I think that states have found a way around that free rider problem in the environmental and other kinds of contexts. So maybe that's another way of doing this. The last kind of suggestion I had in the paper is, if you think of this from a tit for tat perspective, right? Another way to build in reciprocity is just to use tit for tat. And for developing states to say, we're not going to ratify now until more of you developed states do so. Right. And so that might be another way to induce cooperation. And so that's something else I suggest in the paper.
Thank you.
So we want to thank everyone for this wonderful event. And what I also was hoping that everyone could do, we've really had a nice group assembled, but we haven't seen your faces. And so it would be wonderful if you can. I understand you may not be Zoom presentable, but if you are and can turn on your camera so we can all, as we say goodbye, see each other, that would be very much appreciated. We appreciate not only you taking the time today and those of you who spoke, sharing your work, and those of you who are sharing comments and thoughts and suggestions to those who shared their work. That's wonderful. And of course, for those who were able to join yesterday for our event, we appreciate all of you. And I know I personally feel so fortunate to be part of this community. So thank you, everyone.